Jury subpoena said get all information other than the content of a telephone call of all telephone calls in the United States or anything like that?
The admonition in the statute is that it is the types of records that are collected by grand jury subpoena, not that it is an identical process to the grand jury process, because this is quite different from a grand jury process.
All right, the type of data, the type of data is metadata unlimited to specific individuals.
The type of data is metadata, and that
unlimited to specific individuals because it's directed to everybody. It's directed to every phone call in the United States. Can you give me any example where a grand jury subpoena has ever been used for anything remotely like that?
These are instances where we have gone to the court under the 215 requirements with the relevance.
You're not answering my question. Can you give me any example in the history of the United States where a grand jury subpoena was used for anything remotely resembling all metadata, not to specific phones or to specific individuals?
Grand jury subpoenas have a different function than a 215 under the Patriot.
I understand that, but the statute
it's hard
says
to equate the two, Mr. Nadler. You're
not answering my question. You're deliberately not answering. We know they have a different function, but the statute says that it may only require the production of a tangible thing if such a thing can be obtained through a grand jury subpoena. Could you obtain through a grand jury procedure all metadata without being limited to specific named individuals or specific listed telephones?
I think it would depend on the circumstances, the limitations that the court...
Okay. Is there any instance in history...
of the investigation? And then, yes, I think there are instances where a court, in the right circumstances, could authorize it.
And could you give me any instance in history where that has ever been done?
I'm not aware of one sitting here right now.
You're not aware of one. Could you supply us, please, with any instance? Because I believe this is totally unprecedented and is way beyond the statute. And you can't give me any instance because it doesn't exist. So within a week or two, could you supply this committee with that information?
Depending on the restrictions of Rule 6 of the Criminal Rules of Procedure, which prohibit disclosing grand jury information, we'll take that record back for response, or that question back for response.
And can you give us an example where ongoing bulk collection has been allowed by virtue of grand jury subpoena without a showing of a connection between those tangible things and a specific existing investigation?
Well, in this instance, we are showing it as a relationship to a specific investigation and a specific phone number. We have to show reasonable...
Only for use of that information, not for collection of it.
Well,
now, the statute is talking about collection. You're trying to confuse us by talking about use.
But the collection is only there and is only valuable if it is used, and the use is severely restricted.
But we're not talking about the use. The abuse of the statute, the abuse of civil liberties, the abuse of privacy is not only misuse, but miscollection. If you're collecting information about my telephone when you shouldn't be doing that, that is an abuse, even if you simply file that and never use it.
We go to the court and describe to them exactly how the program will work, what the limitations
are. Well, that doesn't help me. The fact that let me answer the question.
This collection.
No, the fact that a secret court unaccountable to public knowledge of what it's doing, for all practical purposes unaccountable to the Supreme Court, may join you in misusing or abusing the statute is of no comfort whatsoever. So to tell me that you go to the FISA court is irrelevant if the FISA court is doing the same abuse of the statute. So, again, can you give me some examples where ongoing bulk collection, I'm not asking about use, has been allowed by virtue of grand jury subpoena without showing of a specific connection, without showing the connection between those tangible things and a specific existing investigation?
Time of the gentleman has expired. Mr. Cole be allowed to answer the question.
We'll take that as similarly as a question for the record. And again, depending on the rules of criminal procedure, we'll see what we can get back to you, sir.
And be aware, of course, that you could give it to us on a classified basis so that we could say our conclusions about that information.
Time of the gentleman has expired. The gentleman from North Carolina, Mr.